I think the first question that I'd like to ask you, and we can just sort of take it from there, is what is the user-survivor movement, and how did it begin, and what are the contours of it, and what were the user-survivors of psychiatry really talking about and fighting for, and continue to in many places.
I suppose, Aparna, where we would need to begin from is especially also the way in which you've titled your panel. I think what is distinct in terms of why they call themselves or refer to a user and survivor of psychiatry is that if psychiatry is a healing profession, or if you're providing treatment and support to people who are supposedly in distress, then why should people refer to that they have to survive from this healing? And I think the most critical point, and which came in both the presentations or both the testimonies, was that unlike other healing professions, this is one profession wherein you could be treated even if you do not want that treatment. Even if you are saying, this doesn't work for me, whilst we have provisions by which you can ask for help, or you're asking for psychiatric treatment, and that asking, at that point of time where you're asking for psychiatric treatment, you supposedly have judgment. You know what is good for you. But when after taking psychiatric treatment, you say, I don't want it, this isn't working for me, then you lack judgment and someone else can decide for you. And that is a provision that has been made. I mean, it's there in the profession and it's there in the law. And this alliance that is there between psychiatry and law, that means you can be compulsorily given treatment which you don't want, which is why both were speaking in terms of, like some kind of a prohibition of forced treatment. Nobody is saying, there are lots of people, and we have innumerable stories of people who've kind of gone to psychiatry and found it useful, even used the same drugs and it worked for them. Maybe it gave that kind of break and you moved on. The difficulty that you have is that when your no doesn't matter, when you're saying, I don't want it anymore, that's the time where it becomes oppressive and you need to be, you see yourself as a survivor from it, because you have to do that kind of public protest and say this is not acceptable. When individual people try to do it, you get locked up and thrown away, and you can't, it's therein that, the movement came into being and people started sharing their stories, like the two testimonies you've heard in there, and started to speak for that. No, if it is treatment, if it is healing, then let me decide, no? If I want to walk away from it, then I should be allowed to do so. And if it's otherwise very effective, then why do you need to compel me? So I would say at essence, that is where the entire problem that comes in there, and why people refer themselves as users and survivors of psychiatry, is because it's not something that they're going to necessarily because they wish to do so. It's like because you're compelled to and coerced to take that treatment.
Right, and how closely do you think lies this entire thing of getting a diagnosis? Does it sort of begin with that? Where do you see it sort of really beginning, this entire taking away in a way? I mean, like you said, there are many people for whom it works, and that's absolutely fine, and that's wonderful. But for those for whom it is not working, is it at the start of that diagnosis that you've been given, which then becomes like almost this lifelong label that you need to carry, that results in this loss of power in a way?
Well, I would say the diagnosis is one of the sites. The fact that either you get the diagnosis and hence a whole range of things happen to you, or you do certain things where people take you to get a diagnosis, See, it's like, and I'm emphasizing, Aparna, on this connection that is made between psychiatry and law. It's like one of those healing professions which is actually wielding a lot of power, a lot of its power coming in from the law and from the state. So it becomes like, if you look at how the law looks at the whole issue of a person, I mean, the term that is used in at least legal terminology is a person of unsound mind. So what exactly are you looking at? When are you sort of asking for a diagnosis, or why you're saying that let's sort of take this person to a doctor, let's find out what's happening? Is you're saying that here's a person who is a danger to self or to others, who is possibly not, making the decisions which you require to make for your own health and safety. And at that point of time, you'll say, okay, now what do we do with this person who's acting out in an unusual manner, the point which Tina was making, or something else which Rufus was making. It's like this sort of, because both of them were talking about in their adolescent periods, like 18, 19, that sort of thing, where you're acting out, you're doing things, and you have a whole range of bewildered people around you who do not know what this means. So one kind of thing which landed up happening was, let's take this person to a psychiatrist, and then if psychiatry gives you a diagnosis, that's one kind of route through which you might enter. The other might be just that you do, the behavior that you may be suicidal, you may be cutting yourself up, you're harming yourself, you're doing some sorts of things which society as such, not comprehending and finding it to be dangerous, feels that something needs to be done. So then you might actually first go to the criminal justice system and from there go to psychiatry. I'm not saying that it's more like, I would prefer to say it's more like unacceptable social behavior, which occasionally gets a diagnosis, very often may just remain in that antisocial space. But in that antisocial space, a lot of people feel that maybe getting a psychiatric diagnosis is providing help and support, whereas if you were to label that same behavior as deviant and criminal, you might go another route altogether. So once that happens, whichever way, whether the law labels you as of unsound mind or whether psychiatry labels you as mentally ill, you are suddenly then seen as an unreliable person, a person who cannot be trusted to take care of their own life. And consequently, then you have a range of procedures and protocols in place as to what is to be done to this individual. So something which may have started out as plain distress, acute distress, and acute distress resulting in behavior which is not seen as accepted behavior, then follows on with that once you get that thapa or that label, a whole range of one by one, your civil liberties are taken away from you, your voice is taken away from you, your choice is taken away from you. And it's like, it's like if every time I look at you and I say, but I'm not looking okay today. You think you're all right? You think I can trust you to go, out and do things? I keep doing it. There's a point after which you'd say, what the hell? And then all that I have done before to prompt that response from you, nobody sees. Everybody sees the response. And then that response triggers off its own, consequences. And usually what tends to happen, say if I'm labeled criminal, or if I'm labeled to be an antisocial element, progressively now we're losing that too, but aside, and I don't want to go into that sphere of what's happening to personal liberties at this point of time and how we are handling dissent. But one of the things which does ordinarily happen is you're supposed to be doing wrongful, deviant criminal behavior that you're charged with, you're allowed to defend yourself, somebody speaks for you, some other things sort of happen. The difficulty with a psychiatric diagnosis is that your dissent gets medicalized. Your deviance gets seen in a manner which is like, it's not you doing it, it's your illness doing whatever it is doing. So from there onwards, you're no longer taken seriously. So each, it's a specific kind of a lens from which people start looking at you, and I think that's the most constraining and the most, I think, frustrating part of a psychiatric diagnosis. And that's wherein the whole business for personhood and legal capacity and all of that came from, because that's what is taken away from you. So it's not just a psychiatric diagnosis. It's not like if somebody tells me I have hypertension, because there's a constant comparison made between mental illness and physical illness and saying, dono illness hai na. For one you go to a medical doctor and the other one you go to a psychiatrist. What is the problem there? But if I am going even for treatment for cancer, and the doctor tells me that you'll have to go through chemotherapy, and we're going to have this particular, like this kind of radical surgery will be performed, and then we'll give you chemotherapy, and then we'll give you radiotherapy, and all that entire, like my treatment regimen is spelled out to me. And I say, mujhe nahi karna, I'm going. I will go for alternative healing. Not a soul can stop you. Can you do the same thing for psychiatric? If you could, then I would say yes, compare. If you can't compare. And that fundamentally is what we need to understand, is what's wrong. There's nothing wrong. Say, if in giving me a label or a diagnosis, you can help me cope with my condition better, and there are certain kinds of accommodations which can come along with, there is something to say for it. But if you're going to give me a diagnosis and take me away from me, then I don't think that that's an acceptable thing. And that's wherein I've always sort of said that if psychiatry has these tall claims of being a healing profession, the first thing that they need to do is sever their relationship with law. They can't be saying that we require the compulsion of law to be providing this treatment. If you are so marvelous, people will come to you. And if they're not coming to you, then please look inwards and see what's not going right. That's how I would sort of like want to see it, sort of thing, or understand it.
Right. You mentioned a particular term, which is the unsoundness of mind. We don't have lawyers here, so if you could explain to us what that really means.
It means what we want to mean, and that's it. That's how law operates. It's a very Alice in Wonderland kind of thing. It will mean what I want it to mean, and that's it. Okay, unsoundness of mind is, you can say at one level, it's a term of art in law. And it really, as such, doesn't mean anything. It's an empty receptacle. And you put a lot of things into it. One way of it is, like, you could say that if you have a psychiatric diagnosis, whether it's schizophrenia or manic depression or whatever, you have that diagnosis, and that diagnosis, you could say, is the threshold condition of why you would be termed a person of unsound mind. So that becomes your first. But in law, just unsoundness of mind, simpliciter, just a diagnosis, doesn't usually mean a whole range of other deprivations come. They would say it should just be your unsoundness of mind should be of a particular kind. So it should be the kind, say, if we're discussing about the fact of whether you can, enter into a contract, that whether you understand the terms of a contract and how it's going to impact your interests. If your, mental faculties are in some way impaired and don't allow you to do that, then that's the kind of unsoundness of mind which operates in the area of whole area of contractual capacity. You could talk about unsoundness of mind in the context of, like, whether somebody is criminally responsible or not, whether you would be held culpable for the wrong that you have committed. There you would say the unsoundness of mind should be of a kind where you don't understand the nature of the act that you're doing, or that it's wrong and it's contrary to law. So you have come up with these various kinds of standards in the text of the law. In the interpretation of the law, what lands up happening is that the moment the threshold condition is fulfilled, the rest almost gets presumed. And that's the reason why it's like, as I have said somewhere that the law has been a great contributor to the stigma that is associated with mental illness. And the law has been a great contributor because the law says that if you are a person of unsound mind, so it's like right from whether you can get married or not, it can be a ground for divorce, it can't keep your child, your contractual capacity, your capacity to manage your own property, your capacity to be virtually do any kind of a civilly responsible act. In the context of treatment and health and treatment, I've already pointed out, whilst we recognize in the law that a person can come forward and seek treatment, so voluntary care is recognized. But if the same person who went and voluntarily sought treatment says, I don't want to continue treatment, we suddenly see it as that it's a doctor who will decide whether my decision to discontinue treatment is a decision coming from a person with judgment, or is it like what they will say, that you were deluded, that your delusion is such which is not allowing you to see what is good for you. When if it was, how was it that I was not deluded when I wanted help? And how is it that I am deluded when I'm saying I don't want it? So it's that kind of, it's like there isn't an area, Aparna, wherein unsoundness of mind doesn't become relevant. In some places, you will say that the standard becomes even higher. That is, if you're talking in terms of testamentary capacity, we are not talking about unsoundness of mind. We are saying you need to have a sound mind. And a sound mind, not that you should not have an unsound mind, but that you should have a sound mind. And it's an extremely interesting area is that, what you see as sound mind. We talk in terms of testamentary capacity, which means I can will, my property and my worldly goods or whatever else I possess to whoever I wish. And yet, when you want to disinherit, people who are your legally recognized heirs, you want to make a preference between, say, your children. You like child number 2 more than child number 3. That's okay. You willed in. And there will be battle between the children, but it's not like your soundness of mind would be so much questioned. But if you decide, I don't want to give it anything to my children, and all of them have enough and more, and I am going to sort of, this many children who live on my street, my property is going to be like a legacy for them. You can bet it. One, of course, your children will be challenging the soundness of your mind. 2, the court will be saying, it doesn't look that you were of sound mind, In the sense of the very fact that when you want to depart from whatever is considered to be the accepted way of doing things, फिर आपके दिमाग में कुछ खलल है.
Immediately means that
it's sort of, and that's why I'm saying is, the entire defining of unsoundness of mind, or what you see as unsound, has a lot to do with what social expectations of behavior are. And if you're departing from those social expectations, like if you, in the whole realm of marriage and the question of marriage and divorce, you'd find constantly you allow for divorce on grounds of unsoundness of mind. What do you give as evidence of unsoundness of mind? Occasionally it would be like anything which is close, even what is it called? Any sort of color of medical evidence, कि एक prescription है, एक outpatient department की ticket है, any of those things would be seen as कि देखो, this person has been taking treatment. The other, and especially because this particular ground has largely been used against women, you would find that, okay, any kind of behavior which is not how women are meant to be acting in a marriage, refused to consummate marriage on the first night, was too friendly with strangers, did not accord respect to my parents, I actually have, not that it was all that weighed with the court at the end of the day, but the very fact that the judge is recording it in his judgment, that she was asked to be boiling 2 packets of milk and she was doing 3, or she was asked to do 1 and she was doing 4, or was using too much soap, or was generally not like behaving like a sugared granny is supposed to behave, like she's not really that efficient house person that she was meant to be. The only point I'm trying to get you to appreciate is that there's a large amount of social expectation. Our behavior is supposed to conform to certain social expectations, and departure from that can often be termed as of being of unsound mind, of being crazy and being mad, and then whatever other else things that you may be doing or not doing. And so it becomes a very, it's a kind of, you could say, a triad, like there is society, there is the law, and there is psychiatry. And when all the three of them converge in the same sort of manner, then you have no place from where you can get yourself, you can opt out of. It's like society saying you should be behaving in a particular manner, you're not, hence they take you either to psychiatry or to law. And psychiatry and law are also saying the same thing, that no, you shouldn't be behaving in this manner, and if you are, then we need to sort of set you right. And you would say it's an unjust kind of an expectation. If this is the kind of marital relationship, I want to have nothing to do with it. I mean, this marriage is suffocating me, and you as my psychiatrist should hear me on that count. And the psychiatrist is telling you or teaching you how to adjust. And so you become maladjusted. So maladjustment and unsoundness of mind and a psychiatric diagnosis and a legal finding, they kind of, in a way, join up together. So it becomes an oppression of authority. And that's why I've always felt, that if you do not wish to recognize dissent as dissent, disagreement as disagreement, then a very convenient way of is the label that you can be getting with mental illness and soundness of mind. I don't want to make it, and I want to say that before that I'm not saying that real distress doesn't exist. I don't want to make it at all. I'm not saying that healing professions are not needed, whichever kind, whether you go in for modern interventions, or you're going for an alternative therapy, or you're just practicing your own meditation. I'm not saying that at all. I'm saying there is a menu card, it should be there. But if there is a menu card amongst the basic principles that we all, unless you want to go for a fixed meal, then you go to a place and you say, I want a fixed meal, comes for 20 rupees or whatever sort of things. Otherwise, you have to have choice. You have to have consent. And nobody at all can be healed if they themselves are feeling oppressed. So consent is a very, very integral component of, and any healer who believes they can heal you despite you is living in a fool's paradise. And I think that's fundamentally, to go back to that other question, what the user survivor movement, what people with psychosocial disability, what setups like this are trying to say, is just this, that this is the extent of diversity, and give people the choice to determine what they wish to do. Have the options available, but don't make those options compulsory.
In a way, the UNCRPD was a huge breakthrough moment, wasn't it? If you could explain to us why that was, what was so incredible about the UNCRPD and what it brought in, and it was ratified by a majority of the UN states, including India, and we will get to what we did after that later. But what was the importance of the UNCRPD, and what did it do for the rights of those with psychosocial disabilities?
Okay, I suppose one of the most integral things about the UNCRPD was that it did not limit itself to only people with physical and sensory disabilities. Psychosocial, intellectual, developmental, it was like the more the merrier, and psychosocial disability, intellectual disability were leading from the front. I mean, I was with Tina Minkowitz, I was a part of the WNSP delegation. So, and amongst the things which was, you could say one of the biggest battles of the UNCRPD was the article on legal capacity. Because it was recognized that if you do not get that article, if it doesn't come through, that you recognize the fact that all persons with disability in all areas of life have legal capacity on an equal basis with others. And legal capacity was not just the capacity to have rights, but the capacity to act on those rights. And it was, at each point of time, I think every time it looked like that the entire thing would collapse, it was around the article on legal capacity. But what was very I think very unique in the context of the drafting process was that the battle for legal capacity of all was not just fought by people with psychosocial intellectual disability. It was seen as everybody's issue. And at different points of time, like it's at one point, I think when we were having a particularly difficult time, the most major statement on legal capacity came from the president, Lex Grandia, the president of the deafblind. At other points of time, unlike what happened in India at a later point of time, you had the blind come up and saying that what makes you think that legal capacity is only the issue of? So it became, and there was a lot of effort by the state parties, by different people to do a divide and rule kind of thing, and to saying, it's their issue. And why do you want to be like having the entire convention collapse because of something that is to be required for people with intellectual and psychosocial disability? And each time the entire disability community spoke in one voice and said, who said so? Whoever said that it's only theirs, and whoever says that it's not going to be yours. So that was one major this thing. The whole question of, in relation to forced treatment, you don't have an explicit prohibition in the convention. They couldn't reach a consensus on that count, but nor do you have a permission. So you don't have a provision like which says that, in the rarest of rare or whatever sort of things, that in these kind of circumstances, in an emergency, you can be doing forced treatment. No, it's not there. But neither is it there that forced treatment is prohibited. What you have is that you have a powerful article on legal capacity. You have the right that everybody's physical and mental integrity would be recognized. So you have the right to integrity, you don't have a permission article on force, and you have an article recognizing legal capacity. So all of these three together, and then after that now the general comment number 1, and now the guidelines which have come against forced institutionalization, all of this is now pushing in that direction where you're saying that no force goes away. And I presume, Aparna, having been a part of that whole drafting process, which was like really, really, in some way, very heady. It was really, you've lived that, you feel that you had a life which was a very different one altogether. But most importantly, I suppose the sort of people with disability across impairments, across regions, across class, gender, coming together and sort of saying at different points of time, nothing about us without us. You don't know anything about disability. You can't talk about it. We know what we are asking for. And so that convention has been, I suppose, of all the human rights conventions, this is one wherein the constituency had a very signal voice. And if you make law which is coming from the people, and you have law which is given to the people, I think that's the basic difference between the CRPD and most other interventions that you get in relation to people with disabilities. That you actually, for whatever reasons, there was a capture of the UN by the disability community. And at one point of time where it looked like that everything that you wanted you hadn't got, so the chair of the ad hoc committee, McKay, he came to all of us and he said, listen, we understand that you want so much more. But if you don't go ahead and get this particular convention, all the people over the period of 4 or 5 years whom you've educated and get them to understand what disability is all about, they will go away. And so don't make perfect the enemy of good. Just go ahead and take and then build from it. So I suppose the CRPD has been one effort in international human rights where the people who said that we are the bearers of these rights played a very signal role in how the text of that particular convention got settled. So that's for people with psychosocial disability, the recognition of legal capacity, the fact that you have a recognition of right to integrity, and you have no permission to use force, I think are the three very signal kinds of benefits. Then evidently when you have right to legal capacity, then all the rights provided in the convention are yours. That's a thing. So.
Could you tell us where we stand in India? Because we have ratified the UNCRPD, but we also came up with a new mental health law soon after. So what are your thoughts on where we stand at this point?
Well, if you have to, I mean, we came up with a mental health law. We also came up with a disability rights law. So one came in 16, one came in 17, sort of thing. Now, if you were to compare the two legislations, I would somewhere say that the mental health care law is much more a legislation which has come from the WHO paradigm, not from the CRPD paradigm. So it's talking in terms of it gives you some little noises in relation to legal capacity, but the way in which those noises have been made is that you make the noises and then it's like, I give you legal capacity, then I take it back the next sentence. And I sort of do this. It's like a very give with one hand, take back with the other kind of mode. More importantly, it's operated on what was the earlier model, the model which subsisted before the CRPD, where you were talking in terms of fair process safeguards. You were saying that, all right, fine, no compulsory treatment or no, but if in the rarest of rare or whatever cases you require, then you have to have all of this fair process. I mean, fair process has been done to death, especially in the US. And it didn't really ever work. It's like to say that you can have a lawyer and he'll be giving you reasons and we will have this one and that. It's like it's living in some fool's paradise. So long as you are permitting compulsory care, you're permitting compulsory care, fair process means nothing. Nothing. It is only on the paper. It doesn't mean anything at all in reality. In comparison, I would say that, though I will personally say, because we were involved in the drafting of the disability law, and what we wanted and what came were not the same. But I suppose after all, one's frustration of not getting all that you wanted settles down, I would still say that there's much, much more potential for a progressive kind of realization of legal capacity in the disability law, not in the mental health care law. And so there would be an entire set of arguments of which one should prevail and all of that. And I presume that, I would somewhere hold that there are arguments which can be put forth for saying that the disability law should have greater stress and emphasis than what you've done in the Mental Health Care Act.
But then how does one choose? How do you, you would have to go into a court of law to sort of ask for your rights. How do you even make sure that it's the right act which is being applied to you? How does it work out in practice?
I would say, of course, one way is that the moment you're compulsorily committed in a psychiatric institution, the mental health care law will sort of become the dominant law. But where you are asserting just the right, nobody is institutionalizing you, you are generating discourse, you're talking in terms of how people with psychosocial disability should be looked at and treated. My thing somewhere is this, Aparna, and I would put it to all of you. There is one way in which we look at the law where we somewhere feel that the law has to tell us what we have to do. So we have to decide which of these two laws and who will be interpreting it, how will the courts look at it, how will the medical establishment look at it, all of that, There's another way of looking at the law, and I definitely do, and that's where the CRPD model has the greatest relevance, is to where you reflect with the law and you say this is what you ostensibly seem to be saying, but if this is what you're saying, this is not acceptable, and why? And that discourse, that reflective discourse with the law is what I feel, like a community like this one should be looking at. You need to be creating that discourse and say, you don't know psychosocial disability better than we do. We are coming from the inside of that condition and we know what we're talking about. And this whole business of, what you consider to be, what should I say, very sophisticated structure that you have so-called created. That sophisticated structure is going to function in this country with these sorts of courts and that kind of police and this sort of resources. What are you talking about? We want a law which facilitates and which lets me do what I think is good for me. I don't want the law to take over my life. I want to tell the law what it should be, like how it can convenience my life. So reflect on the law. Don't try to be in a hurry to use it. Understand it and have this more reflective relationship. That's why I'm saying I narrated that entire CRPD story for you just for this reason, that the biggest lesson of the CRPD was that people with disabilities were able to call the shots. You actually had, I remember there was a meeting that we had where Don McKay, who was the chair of that committee, was educating the civil society that allow for reservations. Reservations is a process by which a country can ratify a law and still say this section or that article will not apply in my country. So he was sort of telling civil society that allow for reservations, because the more number of people actually ratify the convention, the greater will be the traction of the convention. And one civil society member raised her hands and she said, okay, if states can put reservations to the CRPD, can we as civil society also put? And the chair blanched. Because it's a fact is that if you as civil society were going to put a reservation on the convention, the legitimacy of the convention has gone out of the window. It's a power we do possess. I know in today's times we are increasingly feeling we don't possess it, but I actually do think that if renewal is possible, if diversity can become more acceptable in this country again, then it's going to happen from the disability sector. I'm very, very, very clear about that. And I think disability sector itself needs to be needs to be aware of this power that we possess. And so I wouldn't go in a hurry to say which one to choose. I would say let's look at both and see. The Mental Health Care Act has sophisticated language, but very, very obsolete ideas. It is still proceeding under where the psychiatrist is calling the shot. And the more powerful person in that entire statute is the psychiatrist. And the will and preference of the person with psychiatric illness is at the mercy of what is the psychiatrist's judgment. A statute which operates on that premise is necessarily not the statute of our choice. In comparison, I'm saying, I feel there's lots and lots wrong with the Persons with Disabilities Act, but amongst the things, and this is only totally as legal advice, that the Persons with Disabilities Act is openly saying that this statute has been brought in to enforce the Convention on the Rights of People with Disabilities. So whatever, and if that is the purpose of the statute, every provision has to be read in the light of the convention, and the moment you're able to do that, it has much more elbow room and leeway. And I'm not saying it's all sorted, because after a statute is enacted, the struggle actually begins then. I'm only saying in choosing between the two, let's not choose the one which disempowers. Let's choose the one which kinds of at least has some kind of a tuta-futa language of agency and power and choice.
Right. Thank you so much. I want to pause at this point to find out if there are any questions, any thoughts. Can we have a mic, please? No, to her, over here.
Hello. Hi, everybody. Hello, ma'am. Nice to hear you. I came here with a lot of courage. Let me introduce you myself. I'm Arati, and I'm RV's mom. Who knows RV here? Anybody? I'm RV's mom. RV was a 16-year-old child. He was my only son.
Could you use your mic? I think because your voice is going away.
RV was a 16-year-old child. He was my only son. And he left us he has committed suicide. He has been sexually abused, sexually harassed. He has been bullied at school just because of he was exploring his identity. That was his time that he was exploring. After he went, he has written a note. Last note is clearly, I have lot of evidences, everything I have. He was on treatment, he was on psychiatric treatment, psychologist also was taking care of. The case is in court now. After 7 months struggle, I'm struggling alone. After 7 months of struggle, now POCSO has been implemented on kids. They were peers, those who have abused him. Why I'm telling and sharing this to you? First of all, suicide is not a solution. That is not a solution. We have to come out and speak up. But when and where? When children, not getting knowledge at school level, things started from school level. And we go to psychiatrists, we go to psychologists. Me as a parent, I was knowing not much that, but yes, I'm trying my best for my child. Now what is happening, ma'am? Psychiatrists, those who have written, you were talking about whatever they write, that is main document and everything is there, that he has been bullied or whatever. The psychiatrists have written it, everything that is there, now they are backing off. Now they are backing off. And I have no evidence that my son has shared about his sexuality thing. Now I have no evidence that he has been sexually abused, because that was verbal communication between the psychiatrist and him. Now they are refusing. That they don't know about it. So this is an experience, I am sharing it. If you are going for counseling, for therapist, if they are writing it something, maybe, I don't know, the document for you, where you wanted to use that. That should be properly documented, and that should be in email. Whenever I was giving, I'm not going to take the hospital and doctor's name here, but whenever I was sharing that conversation, they were not replying that. They were not replying. And one doctor has given the document which has written that child has been sexually harassed and sexually abused by his peers. That doctor itself is refusing that I as a mother said, write this for my son, just for he got diagnosed, he got dyslexia also, and we diagnosed in class 10th only. He was in class 10th when he's committed suicide. He was in 10th. And that the same doctor is saying, no, mama was forcing me to write that. How can mama force? And for such thing, for abuse. So law, there should be law, many kind of laws which I have to talk about personally. If you give me a chance, I am really looking for a help, like you-minded people. If you come and help I'm working for the community. Those who know those who know my Instagram, those who are following RV story, they know, ma'am, we have started for 200 students. Now RV's followers are 21K. Because you can go through my social media, and there children are sharing ma'am's story. The bullying is still happening. It's too bad. The impact, if they are now in 35 of age, it's still happening. And they are not coming out of this trauma. And schools, principal, teachers, they are not cooperative. Children are saying whatever they wanted to say. My child, they were saying chakka, hijra, whatever they wanted to say, they said it. But nobody took an action. So there are a lot to talk, ma'am. There is, we need a justice for our community children and others, those who are getting bullied. So we need to work on that together. If somewhere I can be a part of it, so let me know. I have a lot of evidences in my hand, but they know she's a single parent. I cannot bribe the police. I'm fighting against a very big organization. If those who are following RV story, they know which school I'm talking about. I cannot name it. But yes, the struggle is worst. And this mom is fighting for the child. And it's not for only him I'm fighting, ma'am. I'm fighting for all community, because they have called me, some of community students, they are my, like my son only, they have called me ki, Mama, please come here. They are calling me Mama. So I also wanted to contribute to society and the country that if this child sacrifice should not wasted.
Thank you so much. I
So
think
please.
that was a very moving testimony, and I think I'm speaking for everyone when I say that we're very sorry for your loss. To lose a child, I think, is really tough. I think somewhere this sort of goes back to what you were saying, Dr. Dhanda, right? Which is that it is socially unacceptable behavior that really becomes, that sort of bears the
trigger
brunt,
point, yeah.
right? And what I find interesting is that, it seemed like help had been sought, but clearly that help wasn't good enough. I mean,
The society do not support, like if he was putting a nail paint, Mama was accepting him, but why the teachers were not
Yes.
accepting him?
Yes.
If he's putting a nail paint,
Yes.
he's putting the earring, if girl can wear it, why he cannot? What
absolutely, and I think that really is at the heart of what Dr. Dhanda also was talking about, which is that, there are two ways really. One is social lack of acceptance in a way, and
talking about community, there is no guideline, they are not taking any workshops.
Absolutely.
Everything is happening at
Absolutely.
And the problem starts from that age only.
Absolutely, absolutely.
They are getting wrong information, they don't know about.
Yeah, and I think that is perhaps a larger sort of problem in society, and that we perhaps need to address. Dr. Dhanda, any thoughts on what she raised? I mean, it's sort of beyond the scope of this panel, but
See, what you're saying in terms of acceptance, in terms of inclusion and a larger conversation, I'm totally with you on it. Whether the remedy lies with the law and the criminalizing of the kind of callousness that you're speaking about, I am not so sure. The reason why I'm saying it is only this much is that, fortunately or unfortunately, you might be able to get certain kind of guidelines in place that this should not be happening. And then you might want the most severe kind of punishment for that wrongful behavior. The implementation of that punishment provision will also have to happen from people who come from the same society. So you might then find that the law hits you a second time by saying, nahi hua. Yeah, this is, either it has not happened, or it wasn't so wrongful, or actually your son himself was to blame. I'm just saying to you that that's the reason why I get the larger thing of creating an environment in which this kind of cruel conduct should be looked down upon. And I think it's important for us to somewhere understand our own power as a society. If you start to say that this kind of bullying behavior, this sort of non-acceptance, is something we look askance on, as a society, that's one thing. To be saying, let's go and get a law, is just going to give so much power to state and its authority and the same functionaries of whom you are a victim. And that's where I'm not, and it's going to happen. I mean, the doctor's going back, or someone else going, or the judge saying, no, that fellow's already died, now why should I ruin the lives of so many other people? But that's how the system will operate. So I'm not so sure whether to take the legal route is the route to the change that you are looking for. I mean, I know I'm a professor of law, but I'm not saying that. I'm saying that, that a condemnation, which, and an environment of saying this is wrong, needs to be happening much more in the society at large before we say, okay, let's bring it. Because to pass a law, to get a judgment, it's not a big deal. It's a kind of flourish that we are very happy to provide for. And then when you actually take that law seriously and expect it to be, implemented in a serious manner, it will not happen because the rest of the social environment hasn't really changed. So I empathize and I totally get from where you're coming, but I'm also sort of saying this to you across like this, that look for your salvation and look for seeing that your son's sacrifice doesn't go down the drain. But look at platforms other than the legal platform before you come to the law. That would be my advice as such. Even if you want to file a PIL or you want to file a criminal complaint and all that stuff, create that kind of a pressure that nobody better take your thing non-seriously. Otherwise, this is the way it will go.
Mental health, nobody talks about at school that much. Counselor is one at school, and mental health is...
No, I think we can't just carry on with sort of...
I see that we've reached the end of the time that was allocated to us. Any last comments we can take, and then I think we should... I think it was quite a lot to take in as well.
Yeah.
Thank you so much,
Thank
Dr.
you.
Dhanda.
Thank
Thank
you so
you so
much.
much for simplifying the law, giving us a different perspective. Thank you.
Thank you so much, and apologies for the delay, because I think the gods above had their own plans.